Mr. Reed, I think that we may be on right now, but we're just going to give it a couple more minutes. There is a phone number that's on here, 818-527-4955. My name is Rob Reed from AskLawyers.com, and this is hopefully one of many where we'll be starting a video podcast to talk to you about legal things in the news or particular legal issues that are going on. My name is Rob Reed. As I said, I'm a California attorney, personal injury. Primarily is what I do, general civil litigation. This guy on the other side, over here, is actually my brother. We are brothers. It's Michael Reed, who is a criminal law attorney in California. And we're outside of this, we're goofballs and little league coaches and soccer coaches and all that good stuff. But we'll get to the nitty gritty of this. How are you today, Mr. Michael Reed?
I'm doing well.
Okay, good. Talk again so I can make sure the audio is okay.
I said I was doing well.
Okay. That's perfect. So if anyone is watching this live, it could be that you are, and you have questions related to civil law in California or criminal law, you can call us at any time and we'll see if it connects, and we'll definitely, it's not filtered, so we may need to edit, but try and behave yourself if you call in. But this particular subject today, we're talking about driving under the influence, but under a different particular nuance, which is if you are caught under the influence and you are, what would you say, intoxicated on marijuana. Is that a proper way to say it?
Yeah, impaired. I mean, the whole idea of a DUI in general is driving while under the influence. Another term for that would be impaired.
Okay. Well, we have from AskLawyers.com, we had a question from an S. Kim in Victorville, California. And he writes and says, I was driving on the 18 near Victorville, and I was pulled over, and I've been charged with a DUI because of marijuana, and I don't know what to do. So, Michael, this is a free advice question really to start, and maybe it'll help someone else, and you can help Mr. Kim here to provide an answer for him. Like, what if you get pulled over for a DUI marijuana, say no alcohol involved in this case, what do you do?
Well, you're a listener. I'm not sure where they are in their case, but just as a general statement, anytime you're pulled over, I'm sure you've heard this before, anything you say can and will be used against you. So the important thing to do is to say little. You have to identify yourself. That is required by state law. So you have to identify yourself, who you are, where you live, license and registration, of course, because you're not allowed to be on a public street without that. But besides that information, that's all you have to tell law enforcement. So I know this is easier said than done, but the most important thing is to stop talking. So if you get pulled over for a DUI, the officer smells marijuana, and specifically marijuana DUI. He smells marijuana, he sees a joint in your ear, which, believe it or not, I have a case just like that. It's a joint right in his ear. Whatever the case, they see a pipe on the floorboard of the car. They're investigating you for marijuana. So when you hear the terms, I just want you to do this test to see if you're okay to drive. I'd like you to step out of the car just to see if you're okay to drive. Anything related to that, the officer is trying to build evidence. He's not trying to see if you're okay to drive. He's already made the determination that he's leading towards an arrest, and now he's filling in his questionnaire that he will eventually fill in later. He's just taking notes for the answers he's going to fill in later. So first thing to do, say little besides what you have to say identifying yourself. The next thing you should do is don't do, and I know that's a double negative, but don't do the field sobriety tests. They're not designed for marijuana or any drug. They're designed for alcohol, which is technically a drug, but we like to separate it out. Studies show X, Y, and Z for alcohol with regard to those tests. There are no studies with regard to marijuana on those tests. So if you do those tests, you create the opportunity for the officer to say, based on my 20 years of experience in doing these types of DUIs for alcohol, I believe marijuana is similar because of X, Y, and Z. Therefore, since he performed horribly on the test, it's an indication of impairment. Don't give the officer that opportunity to make up whatever he wanted to make up. Those tests are not designed for marijuana. Simply stated, you tell the officer, those tests are not designed for marijuana. I don't want to take those because they're not accurate. They're not 100% accurate. And even if this, yes, please.
Sorry, let me stop you there, because I don't know a lot about your area of law particularly, and that's why I don't practice it, and you're much better suited for it than I am, patting you on the back, Mr. Reed. But I do know, I have a friend who got himself into a lot of hot water when he denied, he said no to the field sobriety test, because I believe with the DMV, when you get your license, you have to sign something that indicates, if I refuse, I lose my license. What do you suggest there? Is this person that you described, are they going to lose their license or what?
Excellent question. And there is a test that if you deny it, you sign on the dotted line when you get your license that you will never deny this test. That's not the field sobriety test. That test is the blood or breath, but in marijuana case, it will be the blood evidentiary test. So that is the test. After the initial questions, where are you coming from? Where are you going? Have you had anything to eat today? Have you had anything to smoke today? Oh, you smoked marijuana 3 hours ago. Step out of the car, sir, please. I just want to see if you're okay to drive. After that, and then the initial observations of the officer, would you do these field sobriety tests after you politely say, no, sir, I don't trust those tests. They're not 100% accurate. They're not designed for marijuana. After that point, the officer is probably going to say the words, all right, well, I believe that there are grounds, probable cause here to arrest you, and we need to see if what's in your blood, essentially. Will you take a chemical evidentiary test? Your answer will almost always be, unless you have a particular reason why it shouldn't be this, your answer should be yes. Because if you say no on that test, just as Mr. Reed was indicating a moment ago, he was asking about, is there a test that you will lose your license? This is that one. If you say no to that test, it doesn't matter if you go to trial and you get not guilty verdict from the jury. It doesn't matter if the district attorney's office decides that they are not even going to file charges. There's no case here. You refuse that chemical evidentiary test, you will lose your license for 1 to 3 years.
Now, the only condition that I can imagine where somebody would refuse with a legitimate reason would be what, like a hemophiliac, somebody that can't like clot or something. Would that be it? Would that be a good enough?
That's exactly correct.
Is that a good excuse?
Oh, sorry.
Will that allow you to keep your license, or would you?
Yes.
Okay.
So the quick answer is yes, but the hard part, well, you're going to have to show that to the DMV, because the DMV doesn't automatically know you have some kind of a blood clotting problem. But it's actually written into the law that if you have a type of blood clotting problem, that you can refuse the blood test. It is written into the law. But if here's the catch-all to that, then you have to do a urine test. There's nothing wrong with blood clotting when it comes to urine. So, but that's fine, honestly. And I'll tell you this right now. If you have, a medical condition, and there's only very few medical conditions that this will apply, so don't just try to assume that your asthma or your diabetes or your high blood pressure is enough to keep your license. It's not. But if you have a legitimate hemophilia problem, you're still going to have to take a urine test, because that's going to be the next thing the officer says, at least if they're smart. But I'm going to tell you right now that urine test is just fine. And the reason is urine is not connected to your bloodstream. And what are we testing for? We want to know what's in your blood. So urine, I call the trash of the body. If there's marijuana found in your urine, it could be from yesterday. It could be from early this morning. It could be from a week ago. The funny thing about marijuana is it's fat soluble, so it actually attaches itself to your fat cells. So it is possible that after a while of not smoking, and then maybe you did a little working out, ate less, you lost some weight, that can actually put a little bit of marijuana into your urine. It'll come back positive on a test. But the issue there for me as a lawyer in court is not connected to your bloodstream. It's the trash of the body, says nothing about what was in your blood at that moment in time of driving. So urine is fine with me. And just as a precaution, you can't request urine. So now that you know that urine is the way to go if you got to take a test for marijuana, at least for driving, not there's a whole other issue is if you're taking drug tests on a normal basis because you can't have any drugs in your body for employment or whatever. That's something different when it comes to urine. But when it comes to driving under the influence, you want the urine test for marijuana, but the law doesn't allow you to request it. So urine is no longer really used, and that's why. Because it's so bad. It's not helpful to determining what's in your blood at that moment in time. Like I said, not connected to your bloodstream.
So we want to make sure, we want to make sure that people that are watching this, that they don't lie and say that they have a blood condition, because it'll be found out against them. If their credibility suspect or shot with that, then anything they say in court is going to kill them. So you cannot request a urine test. And if you did, I suppose a cop would be okay. It would say, okay, it's something, but you're going to lose your license without evidence.
Very, very likely. And yes, I want to highlight exactly what you just said.
Okay.
Lying is a huge problem. And one of the reasons I said stop talking in the beginning of this is because you're backing yourself into a corner. And so that's where we have to start, what your statements were to the cop. Because if we stray anywhere from that, you're a liar. So now you're a liar in the courtroom. And if you tell a cop you have problems with your blood and you don't, you're a liar. Nothing can be trusted. So if you honestly, hey, I didn't even smoke pot today, nobody believes you. So it's really important for you to not lie to an officer. One, you can get charged with lying to an officer, which is a crime that will follow you for the rest of your life. You don't want that. But two, it makes it harder for your lawyer. And three, it's not going to help you. So,
all right, well, hopefully the S. Kims of the world, it's not going to help Mr. Kim now, unfortunately, but for folks that are watching this now, I think that's a pretty standard thing on what you should do and not do, which, one, if I'm summarizing you correctly, keep your mouth shut. Two, be agreeable, except for not being agreeable to field sobriety tests that you believe are not designed for marijuana. Three, be incredibly respectful to the police officers. And four, make sure that when a blood test is requested after you refuse field sobriety test, that you accept it in the absence of any reason like hemophilia where you cannot. Because that is where you're going to lose your license. So I think that's pretty solid. Yeah.
I was just going to tell your listeners this as well, anyone seeing this video. Blood test is fine for marijuana. Marijuana is a very fightable DUI. Now, it is...
As of now, studies, right?
Yes.
I'm saying as of now it is. They're probably trying to design tests as we speak to be incredibly reliable to find it in the field, right?
Yes. I mean, there's already been a breathalyzer invented. There's a couple of them invented. The problem with them is they only show presence. They don't show quantity. So it can show that you maybe had some marijuana last night, but that says nothing about your impairment at that moment in time. But it is, the studies out there are so scarce right now. They're really trying quick to develop these breathalyzers, to develop field sobriety tests to determine impairment. But one of the most interesting things about marijuana is one size doesn't fit all. One of the major differences of marijuana and alcohol is scientists have determined, and whether you believe this to be true and whether it's correct for everybody, that's an argument you can make, but the science has determined that alcohol, for example, once you hit that 0.08 and above, science says everybody's impaired, too impaired to drive. That's what science says. Marijuana has nothing like that. That's called a per se law. They've tried to do that in California, and they keep getting stopped. Thank goodness. They've done it in other states like Colorado and Nevada. Honestly, it is all based on zero science. What they're saying is they're saying a certain amount of nanograms of marijuana, THC particularly, in your bloodstream at any given time indicates impairment. That's what they're trying to say. There are two major studies, and these are real studies out there. One is by AAA, the same AAA you call for help on the roadside. And the other one is by the big boy, the National Highway Transportation Safety Administration, NHTSA for short. They're the ones who designed all the field sobriety tests out there in the first place. And they're the ones who helped set guidelines for safety on the roads. Their study said, and it corresponds with exactly what the AAA study said, the number of nanograms in a person's bloodstream at any given point does not equate to impairment. So in simple English, what that means is that one person could have 5 nanograms of THC in their blood and they could be impaired, possibly. Another person can have 5 grams of nanograms of THC in their blood and have no impairment whatsoever. So it really comes down to your use. If you're a frequent user, and I like to say chronic user because I love that term, if you're a chronic user, a low nanogram amount in your bloodstream is not going to be an indication of impairment. For example, I've had a client who smoked marijuana 2-3 hours prior and had 19 nanograms of active THC in their bloodstream when they took the blood test. Now, any person who smoked marijuana before or indulged in marijuana before knows that 3 hours after ingestion, you're not in the same mental state, at least that you were at, within a few minutes of smoking. So a normal user understands that after a few hours, definitely it's not going to be the same effect than when you just smoke. But the important thing to remember about that and why it's so fightable is that prosecutors like to stick on that nanogram level and say, oh, he's impaired. Colorado said he's impaired at this level, so he must be impaired here. Colorado didn't use a single scientific study to make that 5 nanogram level that they created, which is current law in Colorado. 5 nanograms. You can smoke 3 hours. 3 hours later, you could still have 19 nanograms in your system, wow. But according to Colorado, all you need is 5 for impairment. It's a joke. It's
back to the refusal of the test. Since they now have breathalyzers particularly for marijuana, it's still okay to say I'm going to refuse those? What would you say in refusing?
No, it's the same. It's the same rules. It's the same guidelines. So if you're pulled over and the officer says, I believe you're under the influence of marijuana, if you refuse that chemical blood test, it's the same refusal rule.
Well, not the chemical one. I mean the breathalyzers that are specific for marijuana. Can you refuse that without losing your license?
At this point in time, yes, because they're not official tests yet. If you come across one right now in the field, they're a prototype. So they're not part of the evidentiary chemical tests at this point in time. At this point in time, when it comes to the DMV with refusal and losing your license, and marijuana, which is classified as a drug, it's all about that blood test. Or if the blood test is not available, or if you're unable to take the blood test, meaning you have that blood issue, then you must submit to the remaining test, which is the law says is urine. So that is what you need to focus on. The breath test right now in the field is a prototype for marijuana, and if you come across it, you can refuse that. That's at this point in time.
And this is March 18th.
2019.
Yeah, March 18th, 2019. If it's tomorrow, we don't think that it's changed, but be careful. As of this moment, you can refuse that breathalyzer. So,
but it's coming. It's coming.
What happened over there? Did your dog knock something over?
Oh, yeah, that was my dog, unfortunately.
There she is. She's going crazy. All right. Well, there's a little levity there on something that is very serious, and hopefully this will be helpful for folks. But tell me a little bit, Michael, about what you do. Most of the cases, maybe percentages, whatever you want to say. I know you practice criminal law in the state of California, particularly LA and Ventura and probably Riverside County, San Bernardino, all of Southern California. But go ahead. Let everyone know what you do.
So I've been practicing law for, I believe this year will be 8 years. Wow. That's ridiculous.
Yeah, it is.
And I primarily focus on criminals. So that goes everything from a traffic case. Honestly, you can include that because it's the same standard. It's beyond a reasonable doubt. So that could be anything from a speeding ticket all the way to murder, essentially. So I actually developed a little niche in DUI law. I started to become an expert on it. So that is an area that I have a overwhelming amount of knowledge about, but I have knowledge in almost any criminal case. And you know, criminal cases are all very similar. Of course, each different type has little differences to it. DUIs actually
That's Snow. She's a husky. You should bring her in. You could show her in the video there. I think I saw you pick her up.
I'll bring her over in a moment. I just threw her massive bone outside.
Okay. Well, this is the first show that we've done. We'll probably do many others. You got a little blurry there. And so you can be reached at asklawyers.com/readweedlaw. It's down below. You could point down for you. It's over. Oh, sorry, right there, down there. And someone can use that website in order to ask you particular questions. They'll go directly to you. She's throwing it now. Do you have a phone number where somebody can reach you?
Absolutely. So you can reach me and this beautiful girl.
She is. Snow.
At 818-975-0420. And you can email me as well at readweedlaw@gmail.com, as well as michaelreedesq@gmail.com.
I didn't
know. And Reed is double E.
I didn't know 0420. You got that little specialized number there?
I got that. I got lucky. And it's 818. I got lucky.
Very, very good. So do you have anything to add for Mr. Kim or anyone that is... or if
Mr. Kim, especially if your case is still in the court system, just understand that you have the ability to fight that case. So if you haven't chosen a lawyer yet, make sure you choose a lawyer who understands marijuana law itself. DUIs are a certain niche, and there are a lot of attorneys out there who say that they practice DUI law, but they don't know a lot of what they're talking about. So you want somebody who's been in this area of law for a while, and somebody who goes to that courthouse often, because and this goes for anybody out there. Not always, but a lot of times, personal relationships with the prosecutor, you see them all the time, does help. I'm not saying we get special favors, but I'm saying that when there's a moment where it's on the fence, could go either way, if you have a good personal relationship with that prosecutor, it goes hopefully the way you want it. So
would it be
good luck to you, Mr. Kim. Oh, yes.
Would it be fair to say, just from a little bit that I know through you, maybe make sure that you don't drive? Well, number one, don't smoke marijuana and drive at all. I think we both would agree with that. It's not a good thing. But if you do smoke and there's an emergency or something, don't be in Ventura County. Is that helpful or
Yeah, definitely. I mean, don't drive while high, don't drive while drunk. It's not worth it. Uber is always going to be cheaper.
Oh, yeah.
Walking, bicycle, you can get a friggin' DUI on a bicycle. But walking, Uber is always, or cab, Lyft, whatever, is always going to be cheaper. And if you are going to be arrested of a crime, do yourself a favor and don't be arrested in Ventura County or Riverside County. Because the district attorneys in those courthouses, especially when it comes to DUIs, but a lot of criminal cases, they're really harsh to defendants. They've kind of forgotten that defendants are people too. So, beautiful county. I love Ventura.
You were in my wedding party. There is a judge. I'm not going to say his name. We're not going to say his name, but I know a judge in Riverside County who was a very good prosecutor, and he's probably exactly who you're talking about, but I don't think he handles these cases anyway. So, or he or she, I should say. But it probably, since he was in my wedding party, I usually don't have gals in your wedding party. Maybe I did. I'll leave it at that.
Maybe.
Yeah, exactly.
Maybe.
So Michael, my brother, Mr. Reed, thank you for enlightening the viewers on DUI marijuana in California, and they can certainly contact you at the domain, the website that's listed here. But I thank you for your time. I'm sure we're going to be doing this again. We'll probably talk about legal issues. This is the first incarnation of this. We'll figure out how to start getting call-ins and pre-announce the live shows and things. My name is Rob Reed, and I practice in Sherman Oaks, California, general civil, but I do adoption surrogacy, I do business startups and contracts, but primarily bread and butter is automobile accidents, and there have been a lot of rains recently. So if you need some help, you can reach me down below, asklawyers.com/Rob Reed, or you can reach me at 818-783-7998 is my office number, or rob@asklawyers.com. Super easy. So that's it, Mike. If you don't have anything else to add, then hang on tight. I'm going to stop the streaming, and we're gonna still talk. So check out asklawyers.com for any of your legal needs, any questions. It's a one-stop shop for you to submit your legal question that's automatically sent to attorneys in our database. You don't have to do an exhaustive search. Hopefully there's attorneys in our database who are ready to answer your questions within 24 hours. And if not, for free, it's a free service, we will help you find an attorney in your area to assist you. Hopefully. It's not a free advice service, but we'll do our best to try and get an answer to your question. And maybe if you are asking free advice, and it could be in any state, we'll try and find an attorney that might be willing to answer and come on a show in exchange for advertising his or her law firm. If you're an attorney, sign up. It's $19.99 to join, one-time fee for a lifetime as long as we exist, or $79.99 for a premium membership annually, where you get questions right away. There's a 24-hour delay for basic free membership. On that note, thank you for watching. Michael, thank you for your help, and we will chat soon.